I'm Colin Singer, immigration lawyer and managing partner of Immigration.ca. Canada Immigration News Articles, August 2015. Federal Court rules Canada's refugee policy is unconstitutional. The Canadian Federal Court has ruled that denying certain refugee applicants the right to appeal is unconstitutional. Canada's discriminatory refugee policy mostly affected Eastern Europeans fleeing persecution, with the court ruling that the Canadian government violates equal rights under the law by denying refugees from so-called safe countries the right to appeal when their applications are refused. The ruling immediately allows refugees from 42 countries the right to appeal. The distinction drawn between the procedural advantages now accorded to non-designated countries of origin, refugee claimants, and the disadvantage suffered by DCO refugee claimants under the policy is discriminatory on its face, wrote Justice Keith Boswell. It also serves to marginalize, prejudice, and stereotype refugee claimants from DCO countries, which are generally considered safe and non-refugee producing. Critics of the refugee policy often point to the big contrast between this policy and the country's pilot investment immigration program targeting foreign millionaires. The ruling is said to be a big blow to the Harper government, which attempted to overhaul the refugee system. The government, in its defense, stated that their refugee policy was not discriminatory because it allegedly used nationality only to inform the relative safety of the countries they were fleeing from. The Canadian Romani Alliance says that racial profiling by border officials against Roma community members peaked in 2011 when visa restrictions were removed for Hungarian visitors. It was then that asylum claims from the Hungarian Roma community, who were trying to escape life-threatening anti-Roma persecution, reached an all-time high of 4,400. But since Hungary was listed as a safe country, Canada began to reject most of these asylum claims. Even though Romas do not need a visa to come to Canada, they are kept out of the country. This is a form of discrimination, an example of racial profiling by the Canadian government, says a member of the Canadian Romani Alliance. The ruling has been welcomed by refugee groups. Prior to the ruling, refugee policy provided asylum seekers only 15 days to file their claims, and it did not allow them to work for 6 months. Source: telesurftv.net.